All right, a bombshell report tonight about how Elizabeth Warren, Senator Elizabeth Warren, and her office coordinated testimony with the Security and Exchange Commission ahead of a Senate hearing. The Heritage Foundation Oversight Project, of which I'm associated, through a FOIA request, obtained emails from Warren's office to the office of Chairman Gary Gensler 2 days before his Senate testimony back in September of 2021. The email from Warren's economic policy advisor includes a list of questions. Get this, a list of questions that Senator Warren planned to ask, along with suggested answers for the chairman of the SEC.
This is outrageous, guys. I don't care if you identify politically as a right, left, middle, unicorn, or one-legged salamander. This is outrageous on so many levels that it's difficult to even put into words. We are being intentionally played. The SEC is a useless, corrupt relic of an institution that should be rebuilt from the ashes. And now, due to the actions and lawsuits put forward by the SEC and the bear market that we are in, the largest crypto exchange in the US, Coinbase, only has 20,000 visits per week. 20,000! In the meantime, its competitor Binance has over 14.5 million weekly visits. The SEC and Gary are doing a great job stifling innovation and leaving America in the digital stone age. Seemingly now, people are more than just frustrated, but they're tired and angry with Gary and the SEC, with their corruption and also their cluelessness when dishing out the securities lawsuit towards exchanges and tokens. And one of the frontrunners in battling against the SEC now would be John Deaton. Lead plaintiff in Zakhanov's Ripple case was a day trader, says Deaton. Now, I did cover some of this in a video yesterday. By all means, check it out in the description down below. But in this video, I'm going to cover it in a bit more depth. So to start off with, John E. Deaton, the XRP lawyer and founder of Crypto Law, provided explanations for his recent proposal to file the amicus brief in the lawsuit against the crypto exchange Ripple Labs, commenting that Vlad Zakhanov, the lead plaintiff in the class action case, is a day trader who bought and owned and sold XRP in just 2 weeks. Deaton tweeted that Zakhanov commented when he bought XRP, he was relying on the efforts of Ripple because they promised to get financial institutions to use XRP. On February 9th, Deaton, along with 5 other XRP holders and the crypto company Spend the Bits Incorporated, filed a motion to file an amicus brief in the Zakhanov vs Ripple case on behalf of 75,890 XRP holders from different countries. Following the proposal, Deaton updated his Twitter today with a series of tweets enlisting the reasons for filing the amicus brief, with the inscription, "The secondary market must be protected." As you can see here, the secondary market must be protected. Johnny Deaton filed a motion asking the judge for permission to file an amicus brief in the civil class action lawsuit versus Ripple, which was filed in May 2018. The reason John filed the motion and why he has fought so hard to become an amicus counsel in the SecGov vs Ripple case is due to secondary market transactions. We have to stop the narrative that software code is a security. Bitcoin, Ethereum, XRP, etc. stand alone are nothing more than alphanumeric sequences. Math, digital code, software. The token itself is not a security. A token, like any other asset or commodity, can be packaged, marketed, offered, and sold as an investment contract. Now let's cover something known as the Howey test. John Deaton explains that imagine someone buys an orange grove from the Howey company, sits back and relies on Howey to do all the work, and then the buyer gets his pro rata share of profits. We can all agree the above scenario meets the Howey test, and with an unregistered securities sale. And now here's a hypothetical for you guys. Now imagine the person who purchased the orange grove directly from Howey dies. His estate sells the land to a new buyer who has never heard of the Howey company and knows nothing about the circumstances surrounding the original sale. In other words, the orange grove forever remains tracts of land even though it was sold as a security. Through the years, since Howey was decided, many assets or commodities have been packaged or schemed into an investment contract. The Howey test doesn't change for crypto. In fact, In 2013, there was a SEC case and Bitcoin was sold as an investment contract, and after that case was decided, guess what happened? Some people at the SEC and others started saying that Bitcoin itself was a security. Bitcoin, guys. The argument was that investors expected a profit and were relying on the efforts of Bitcoin miners, so Bitcoin was a security. People forget or ignore the fact that the Howey test is meant to be applied to specific transactions, not the underlying asset. Even as Satoshi sold Bitcoin early on, it wouldn't mean Bitcoin is a security. If Ripple offered / sold XRP as a security, so what? Ethereum's ICO was an unregistered security offering, but it doesn't mean Ethereum is a security. In an investment contract, the underlying asset is not a security. Yet Gary Gensler and the SEC keep focusing on the token itself, which is not the case. That's not what you should be doing, calling the vast majority of cryptocurrencies themselves securities. Again, that is not what a security is. The problem is that smart, influential people, other than Gensler, are pushing this false narrative that tokens themselves are a security. Now guys, I briefly urge you to listen to what Saylor is saying in his discussion with Raoul. I'm not going to play the whole of this video. If you guys want to watch it, I'll leave a link to it down in the description below. But John E. Deaton further goes on by saying that Saylor is a rocket scientist, so he has to believe that he knows what he's saying is not accurate. XRP is a software code. Even if Ripple sold XRP in an unregistered securities offering, it doesn't mean that XRP itself is a security.
Gensler says this to the Senate yesterday, I quote, "If it stays outside of the public policy framework for AML, tax compliance, and investor protection, it is not going to long persist," unquote. I think that's pretty clear what he's trying to tell you.
The issue I've got with all of this is I get the AML, I get the tax stuff. It's the stupid securities law from 1933, 1934 that doesn't make sense. It makes it highly restrictive in who is able to access certain things. It's that what is a security is we're trying to fit something into a wrong framework.
Yeah, well, I mean, that's what the crypto guys
Because
would
anybody
say,
can buy a house. If you say it's a property, everybody should be able to buy it.
Yeah, but Raul, if I created my own Mikey coin and then I pumped it on Twitter and I dumped it on the retail population after I gave a bunch to a celebrity who then told the world it was great, it's illegal and it's unethical.
Now, I don't know about you guys, but I did find that very insightful. And like this account said, no one saw this interview coming. Now, John Deaton filed a motion asking to file an amicus brief in the civil class action case because the plaintiff's attorney is asking the judge to certify the proposed class to include all XRP purchasers who acquired XRP from May 3rd, 2017 until the present day. However, the proposed class is not limited to direct sales of XRP offered and sold by Ripple or its executives. The proposed class includes all secondary market transactions. The only way all sales can be included is if the asset itself is a security. It's an absurd position. And then, John Deaton further narrated the hypothetical solution, claiming that the lead plaintiff has never relied on Ripple's efforts, or else he wouldn't have sold it within 2 weeks. In addition, Deaton said that the case should be limited to sales offered directly by Ripple, by which he meant that it should exclude the secondary sales around the world. I'm sure it is far from over in this battle between SEC, XRP John Deaton, and the rest of the crypto world. And just before I finish off this video, just to show you guys that XRP is currently sitting at 0.3827, and we are still in a bearish trend, currently sitting at minus 0.16% for this day. Anyways, thank you for watching this video, guys. Just to let you know, I'm not a financial advisor and it's not financial advice, so please do trade at your own discretion. I'm really just stating my views based off of my own research, but otherwise, if you want to keep up to date on all the hottest new crypto coins that are going to catastrophically blow up and make you the most gains possible, then please feel free to subscribe to the channel and turn on the notification bell as well. Like the video and drop a comment down below on your thoughts on what coin you'd like to see next. But remember, guys, it's just a coin, and I'll see you in the next video.